My grandfather and great-grandfather started Junction Auto in 1931.
If you want to pay more, that's your business. If you want to pay less, that's my business.
At this time, it is the understanding of the state of Ohio that the defendant will enter a plea of guilty to the count 1 of the indictment, that being aggravated vehicular homicide, a violation of revised code 290306A1A, felony of the second degree. She will also enter a plea to count 2 of the indictment, that is operating a vehicle while under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the first degree in violation of revised code 451119A1F. Count 3, to wit, aggravated vehicular homicide in violation of 290306A2A, a felony of the third degree. Count 4, to wit, operation in willful or wanton disregard of the safety of persons or property, a minor misdemeanor, a lesser included offense of count 4, a minor misdemeanor. And on count 5, Your Honor, a lesser included offense of count 5, and that would be attempted failure to stop after an accident in violation of revised code 292302A, which conduct if successful would constitute a violation of 454902A, a felony of the fourth degree. And then the 6th and 7th count, Your Honor, that she would enter a plea in violation, endangering children in violation of revised code 291922C1, misdemeanors of the first degree. The state would not oppose judicial release whenever the defendant would be eligible, and that the parties agree that the misdemeanor counts are all to be merged in any sentence that is imposed by this court, as well as the third count, that being the aggravated vehicular homicide, merges into count 1 for purposes of sentencing, Your Honor, and that the count 1, the second degree felony, any time imposed by this court be considered mandatory actual time.
Very well. What is your plea, ma'am, to count 1, the charge of aggravated vehicular homicide, a felony of the second degree?
Guilty.
Tell me what happened on the day of the event, May 23rd, 2011.
I was driving home from my son's baseball game, and the weather was getting bad, and I did not notice anything in the road because the trees were coming down, and I honestly thought I hit a deer. And my daughter said, "No, I think we hit a deer." And the window was shattered, and my daughters were crying, so I dropped them off at home. And then I came back, and it was a quarter of a mile from the accident.
Anything to that? And ma'am, what is your plea to count 2, operating a vehicle under the influence, a misdemeanor of the first degree?
Guilty.
And tell me what occurred there. Were you drinking?
Yes, earlier in the day, yes.
How much did you have to drink?
Maybe a glass like this.
But you agree that you had something to drink that day?
Yes, sir.
And as I recall from last week, the testimony indicated you said you had taken prescription drugs.
I have.
Did you take prescription drugs on that day?
I took a Vicodin at 2 o'clock, yes.
So do you agree that you, by your actions, took another person's life?
Yes.
What is your plea to count 5, attempted failure to stop after the accident, a felony of the fourth degree?
Guilty.
And did you fail to stop? You already said you left the scene and went home.
Yes.
And that was how far?
A quarter of a mile.
And then you returned?
Yes.
And how long of a time did it last?
Minutes, because I just took my 2 daughters out of the car. So the glass all over, and they were crying.
Very well, the court will accept your pleas of guilty on counts 1 through 7. Very well. Court will stand adjourned.
Rise.
obviously nothing brings back Judge Henry, but certainly this plea today was in the best interests of the family and getting this matter resolved. It's been a long, hard road since they lost their husband, father, and obviously it's just been a terrible thing for not only their family but our community, and we're glad to get it resolved today. It's a horrible case, and two families were obviously ruined, but in the end of the day, justice was served by having her plead guilty to those things that she did. That was driving a vehicle that evening intoxicated and killing the judge, and the fact that she left him there on the side of the road afterwards. Now, obviously, she had some concerns that she was taking her two children home, and I think the Henry family, by validating the plea, took that into consideration.
How do you think the family feels that she still admits that she thinks she hit a deer? She's still not owning up to the fact that she hit a person.
I think that they had an opportunity this morning. It was one of the first times I've ever been involved in something in my 30 years of having Ms. Cox go before the Henry family and make an apology in person. It's sort of detrimental to the process to have her come in and still admit she thinks she hit a deer, but that I think the healing with this plea is starting for all families, and they're going to move forward with it, and it's too bad that she didn't just come out and say that she knew she hit the judge. Nothing brings but a chip back. I mean, it's a horrible situation. He was a great man, he's a great lawyer, he's a great judge, and I was there that evening, and it breaks your heart to think that while all this goes on, nothing changes the fact that he's gone. But, you know, in our system of justice, this matter has been taken into consideration by our office and by the defense attorneys. A plea has been entered, and she's going to do the time that she's eligible to do, and unfortunately, while life goes on, it'll bring some closure hopefully bring some closure for the Henry family.
And Dave, how important was, obviously we had the suppression hearing on Friday, but today in court she talked about having one Vicodin at 2 o'clock and a glass of wine, but yet...
That wouldn't get you to .284, and our testing and the work we've done on this case would have shown that she was in excess of .3 at the time of the accident.
So in terms of what she told the judge today, she has a story that's different than what the state believes is the truth.
She has a story. We would have proved otherwise.